Ladies and gentlemen, thank you so much for staying throughout the day for this last session of this Legacy Conference. I start by thanking the organizers and my profuse thanks to Judge Aegis and also Professor Carsten Stahn for the honor of inviting me to moderate this event. It was about 21 years ago when I had slightly more hair, not much, but a little bit, that I walked very proudly into the ICTY as a junior prosecuting lawyer. And I worked for a very wonderful gentleman, senior trial attorney Erik Osberg from Sweden. In those days, there was only 3 senior trial attorneys, Mark Harmon, Grant Neiman, and Erik Osberg. And I was a junior lawyer in the Celebici case. And really, all these years later, we come to this week. And it is a week, really, of mixed feelings. Of course, the tribunal has many achievements. But I think Patricia and others mentioned it. It also created a camaraderie, a brotherhood and sisterhood amongst disparate groups, lawyers, whether they be judges, prosecution, defense, or court staff, that work together in one direction of trying to make this, what many thought to be an experiment, work. And at the end of this process, having had the privilege of defending in 4 trials at the ICTY, as well as prosecuting, I think the greatest accomplishment is that nobody can say there has been a miscarriage of justice. And I think that, more than anything else, is the biggest achievement. No one can say that any individual has been wrongly convicted, because miscarriages of justice, of course, occur in domestic systems. But they are mitigated to some extent by the fact that they are domestic judges in a domestic system, or domestic police officers, that somehow the process doesn't work and it gets it wrong. But if this court, if this experiment had given rise to blatant or real miscarriages of justice, the whole future of international criminal justice may well have been in doubt. So that is one clear achievement. The other, of course, has been touched upon by Carsten Stahn. He described it as bringing the ICTY. The ICTY brought out the law from the books. What it clearly did is take away theoretical concepts away from bastions of learning in universities, and even beyond that, brought it into the corridors of diplomacy, but even into the bars, into the restaurants, not just in the developed world of The Hague, Netherlands, or New York, or London, or Paris, but even in the bars or the restaurants of the developing world, not just Africa, but also Asia. There is this idea that the law is supreme, that there is some mechanism, that when there are gross violations of human rights, somewhere, the city of The Hague, there is some mechanism that can hold individuals accountable. So there's great cause for optimism. But at the same time, have we reached the high watermark? The ICTY was followed by the ICTR, the Special Court for Sierra Leone, the extraordinary chambers of the courts of Cambodia, the special panels in East Timor, the STL. But is that the high watermark? Is the tide of international law receding, given the current political state of affairs in the Security Council and the ever-shifting fault lines that are becoming daily apparent, not just between Russia and the United States, but even in the Middle East? New alliances, Turkey, a former NATO member, seemingly shifting alliances. So everything seems unsure. And then we come, of course, to the ICC. And previous speakers have said that if the ICTY had failed, if the ICTR had not delivered, there would have been no chance in 1998 that the Rome Statute would have been signed. But the accomplishment of a permanent building, of a statute, of judges being elected and prosecutors being in place, must be tempered by the discord that is out there. We must listen to states, whether they are South Africa or Burundi. And this poses a very real challenge to the future of international criminal justice. Complacency, a sense that the court or international justice is permanent, is a danger, in my view. The panel we have assembled needs no introduction. Like the panels before, they are a galaxy of stars. We're going to proceed with each speaker talking for about 8 minutes on the general topic of today, which is the future. Looking forward, what lessons can we learn from the ICTY? How can international justice entrench its place and build its reputation further and attract states that are not currently state parties to this idea that international justice is for all, including the powerful P5 countries in totality. And after those 8 minutes, we'll have a second round and then maybe some questions. The biographies, of course, are on the table. I really don't think any of the panelists needs introductions. Of course, we have President Judge Miron, former president of the ICTY, president of the MICT. We have Professor Diane Orentlicher, professor of law at the Washington University, very widely published. Of course, to my right, the president of the International Criminal Court, Judge Flug, a judge of the ICTY, and now judge of the residual mechanism MICT, judge in the Mladic trial, and right at the end, last but by no means least, we have Serge Brammertz, prosecutor of MICT, and before that of the International Investigative Commission for Lebanon, and before that deputy prosecutor of the ICC. We'll start with the observations, reflections, and opinions, not musings, of Judge Miron.
Thank you so much. Today has been a remarkable day for all of us here to reflect upon the achievements and contributions of the ICTY over the last nearly quarter of a century. In this, the symposium's final panel discussion, we have been asked to reflect upon the importance of international criminal courts and tribunals, the significance of the ICTY's work at a global level, and the future of international criminal justice. There is so much that could be said about these matters, but given the time available to us, I will limit myself to a few observations. First, and perhaps most simply, the ICTY has demonstrated that principled accountability for international crimes, by which I mean proceedings conducted in accordance with fundamental principles of law and due process, is possible. This may seem a rather obvious point now, but we must recall that at the time the ICTY was created, no one knew how the Security Council's bold experiment would fare, whether states would cooperate and anyone would be arrested, whether a workable synergy between civil and common law traditions and practices could be found, whether trials would indeed take place, and whether the judgments to which they would give rise would be respected. Over the intervening years, the ICTY has more than put to rest these initial doubts, and in doing so, not only fulfilled its own mandate, but inspired and been a resource for a great many other accountability initiatives all over the world. Without the ICTY, would there have been an ICTR? Would we have seen hybrid courts from Sierra Leone to Cambodia? Would the world's first permanent International Criminal Court, so long on the planning board, have been established quite so soon? And would we have seen so much by way of national efforts to ensure accountability for atrocity crimes in national courts the world over? Thankfully, we do not have to answer these questions, since a result of the ICTY, we live in a world transformed. The tribunal has fundamentally changed how all of us think about accountability, and particularly accountability when it comes to senior political and military leadership. This brings me to my second observation. Thanks to the ICTY, accountability is no longer the exception to the rule. It is increasingly an expectation among members of the public, as well as among diplomatic, governmental, and other leaders. The ICTY, in other words, has changed the basic considerations in play when we are confronted with atrocity crimes, and for the better. In saying this, I do not pretend that every violation of international law committed today will invariably be subject to investigation, and that those individuals alleged to be responsible will be brought to trial. Sadly, we are still far from living in such a world. But thanks to the ICTY, the other international and internationalized courts for which it paved the way, as well as the growing number of accountability efforts at the national level, it is increasingly difficult for political and diplomatic leaders to ignore calls for justice when confronted with evidence of grave violations of international law. This in turn brings me to my third and somewhat more sobering point. For all that the ICTY has achieved over the past nearly quarter century, we must remember that international justice is still very much in its infancy and is, as a result, still in a fragile state of development. Indeed, in a number of respects, we find ourselves today at the critical juncture for international justice generally. Why do I say so? For one thing, nearly 25 years after the founding of the ICTY, we know that international justice, for all its extraordinary benefits and achievements, has been criticized for being costly and time-consuming. There are, of course, a great many explanations for the cost and duration of the work of courts like the ICTY. The fact remains, however, that those of us who wish the fight to end impunity to continue in the future would do well to ask ourselves how justice at the international level can be rendered more cost-effective, more efficient. What new models could be followed? What new innovations could be implemented while still and always abiding by fundamental principles of fairness? These are questions we continue to ask ourselves at the mechanism, which is the ICTY's successor institutions, and no doubt at the ICC and in other fora as well. The past 24 years have also shown us how challenging it is for an international criminal court to operate effectively when subject to the differing and often conflicting expectations of various stakeholders. These differing expectations undoubtedly affect how the legacies of the ICTY and its fellow courts are understood, where the courts will be deemed to have succeeded and where they will be treated as having failed. International criminal justice also finds itself in a precarious stage of its development due to the recent rise in distrust for international and global endeavors and institutions. Indeed, international courts are particularly vulnerable precisely because we find ourselves at the moment of contraction after a remarkable period of expansion with a number of courts completing their work. Here we would do well to remember that while we often speak of international justice and focus on international courts, the fight to end impunity for international crimes is one that requires engagement at all levels. While there will always be a role to be played by courts operating on the world stage, international justice must be pursued holistically and globally in myriad venues if it is to succeed in the long term. This is particularly true when we consider the pernicious problem of selectivity of prosecution, something we must unite to fight against. Looking at the broader picture, international courts can never, on their own, ensure accountability for all of those accused of international crimes. Indeed, even with the best of will and the greatest of efforts, the ICC alone cannot fully address the accountability deficit going forward. National and regional involvement in accountability initiatives is essential alongside international initiatives if we are to bring an end to selectivity, which is an anathema to the rule of law. Finally, I would be remiss if I did not take notice of the impact of the politicized atmosphere in which international courts now operate. An atmosphere that can impact everything from what cases are referred to a court like the ICC, to how the courts, their judges, and their judgments in sensitive cases are viewed. The current political climate is particularly unconducive to either the referral of additional situations to the ICC or to the creation of new ad hoc tribunals. Means must be found to insulate international justice from the corrosive effects of politics and to find ways around political impasse when steps are needed to address ongoing atrocities. Thus, for instance, while the present political climate may be discouraging, it is possible that the major powers in the UN Security Council could reach consensus in some limited areas, such as when it comes to the referral, potential referral to the ICC of crimes alleged to have been committed by the ISIS. Finding answers to some of these challenges to which I have just referred will not be easy, but it is essential if we are to build upon the tremendous strides made by the ICTY and press ever forward to create a future in which respect for the rule of law is paramount and accountability is itself the rule and not the exception. Thank you.
And Judge, could I ask specifically, do you have any new mechanisms or new innovations that you would suggest be taken on board by the ICC moving forward that would improve transparency or improve the environment in which the trials and investigations are taking place?
Well, thank you. Let me first say that I think that the ICC is doing very well in developing innovative methods of work. The problem is that, of course, for changing something significant, one needs, in many cases, resort to a change of the statute, which is a very, very difficult proposition. However, if this could be done politically, I would think that there are some examples which I would draw upon from the experience of the mechanism, which could be used for the ICC to a certain extent as well. For example, in the ICTY and the ICTR, we always needed, for practically everything, except for, say, confirmation of indictments, a panel of 3 judges. This is costly, it's time-consuming. The statute, the Security Council enabled the mechanism to operate on very many issues, judicial issues, by resorting to a single judge. As in the entire roster of the mechanism, we in fact have only 1 judge who is working full-time. The rest are working remotely all over the world. And I must say that when we started, I was not terribly optimistic about the prospects of phoning somebody like you in London, who has a great criminal law practice, and inviting him to do a case which would last 3 or 4 days, and expecting you to say, yes, I will leave other things and give this priority. In practice, except for 1 case, basically, when a judge was busy on the Habre case, and therefore had to ask to postpone a judicial appointments for him, we never, ever have cases where judges do not accept appointments which bring them very little income, and yet indicate their very great commitment of those people to international criminal justice. So yes, find a way to have single judges being able to do some of the work of the ICC, to make it more economic, and perhaps even to operate more rapidly. This is one of the examples.
Can I just ask a supplementary question, if I could? Judge Ori mentioned in the earlier panel about, or maybe there's a question about micromanagement, and Judge Ori said, well, there needs to be management, otherwise there'll be chaos. And in the, particularly towards the end of the tribunal's life, there was a more robust, perhaps, insistence by the judges that the prosecutor frames his or her cases more prudently, so not to overload the indictment. We see in the ongoing case now at the ICC, situation in Uganda, former child soldier, there are 70 counts on the indictment. What lessons, if any, did you draw in relation to judicial intervention in advising or persuading or ordering the prosecution to put forward a reasonable number of counts so that a trial could be fair and expeditious and come to a conclusion within a reasonable time?
Well, I'm grateful to Judge Ori for raising this point. I think that this reflects not only the need for a more robust management of what is happening in the courtroom, it also reflects on the more fundamental question of synergy between common law and civil law. We in the tribunal, it was before I became a judge, started from a system which was almost pure common law. A judge was almost an arbiter in a football game, sitting up there and allowing the parties to develop their cases. Over time, we found that while desirable in many respects, this was not the most efficient way of conducting extremely complex, extremely sensitive international criminal cases. And we felt that there are aspects of civil law which we would be wise to try and incorporate in our practice. One of them, to give a more robust, a more potent role to the presiding judge. And this has eventually led to being reflected in our rules of procedure, which enabled us to lay down somewhat the directions to the prosecutor and say, well, do you really have to prove that crimes against humanity were committed in 47 municipalities? Couldn't you make the point just as well by focusing on 12 or 20 municipalities? But this went beyond that. For instance, we felt that it is not enough to say that we don't follow the hearsay rules of the common law, but that there are certain aspects of civil law procedures, particularly with regard to accepting written testimony, that we would be wise to follow. And over time, the system changed to the extent that I hope Judge Ori and Judge Fluger will agree with me, and Judge Pokar, that in fact, our system of evidence has become more closer to civil law than it is now to common law. And it has brought about a system which I think works better. And to have a judge who plays this more robust role, employing elements of civil law, is a very good thing.
Thank you. Thank you so much. Without further ado, over to Professor Diana Arundel.
Thank you. It's a real honor to be here. And I'm delighted that the ICTY is taking time to have and Leiden University, to have a day of reflection about the ICTY's legacy in a setting that recognizes that we're not talking about the end of a phenomenon, but as I think Judge Odio Benito said earlier, the first 24 years of the ICTY's legacy. As all of the previous comments, I think, have reflected, the story of the ICTY's impact is by no means over. And we're reflecting on its experience today primarily because we know that. We know that its legacy is going to continue to unfold, and part of what we're doing here today is capturing experience that will enable us to do a better job going forward, or the best job we can going forward, as I think someone else said on a panel. I'm going to take as a given the challenges to which Judge Miron and Mr. Khan have referred, and just acknowledge that we all know what those challenges are, and they're huge and enormous. And so that's my foundation. So the rest of my comments are, and yet. So the large question we were asked to address on this panel is what has been the legacy of the ICTY globally. I'm going to, in a moment, link the global impact to local developments, because I think the two are absolutely inextricably related. But one of the measures for me of the global impact, and this really picks up on what Judge Miron said earlier about the ICTY's impact being transformative, is that my students, my law students today, grew up in a world where it was by no means unusual to see a dictator face judgment before a court. And to them, that's so normal that I have to work to persuade them that the Hiss and Habre case was extraordinary. It's ordinary for them. They've never lived in a world where that didn't happen. When I was a law student, and for a long time after that, the norm was that a dictator responsible for horrific crimes on a mass scale had a lovely retirement, often in relative or great luxury. So that's a transformation. What's more kind of an important question to try to get a hold of is, so what's happening beneath the surface of that, and will that phenomenon change if if the challenges that Judge Miron just referred to become greater? Are we going to see fewer and fewer of those kinds of prosecutions? I think there's some really important and interesting work going on now by social scientists who are talking a lot more to international lawyers about what kind of changes within countries help give rise to the demand for international accountability as well as domestic accountability. So just one, to mention one example of the kind of research I'm talking about. As I was mentioning last night to Judge Miron, there's an article in what I think is the latest edition of the American Journal of International Law by two social scientists who found that, and I hope I'm getting this right, that in countries, at least in Africa, in which the ICC opened an investigation, there were 5 times more human rights prosecutions per year after an investigation was opened than in other African countries. So that's just one statistic. There's something really fascinating going on. And so the question is, what is that dynamic? How are international tribunals catalyzing change domestically? And how can we capture that so that it's not incidental and accidental but wonderful, but something that we can try to consciously work toward? One of the conclusions of the authors of that study that I mentioned was that this was an sort of inadvertent type of positive complementarity, not the kind that the ICC planned, but it happened, and we should try to understand why. So I think a key part of the answer, one of the most important parts of the answer, is understanding how international justice interacts with domestic actors. And in my view, the linchpin of the future of international justice in terms of its positive impact turns on the way it interacts with local actors who are pressing for reform in difficult countries, in difficult circumstances in their own countries. One of the theses of the article I just mentioned, in fact, is that the ICC, by opening an investigation, helps provide a wider space and support and cover for domestic reformists in difficult situations. What's important to recognize about that point is that we're not talking about easy situations. We're by definition talking about countries where mass atrocities occurred and where there's continuity from the prior regime in powers, in structures of power. And yet we also have reformists who are working for change, and they're working in constrained and contested and difficult circumstances. And so the thesis of the authors of this study is that the ICC, by opening investigations, not in every country, but in many countries, has helped widen the space for reformists. I want to turn that point to the the ICTY and its experience. An earlier panel talked about the relationship of the ICTY to domestic prosecutions in Bosnia and Serbia. I think that's one of the most important legacies of the ICTY, and as we also heard, and perhaps Mr. Brammertz will say more about this, that legacy is fragile and faces daily perils. While the ICTY has operated, the OTP has done a really marvelous job of providing support for those institutions when they face challenges. That's going to become more challenging going forward, but it's absolutely necessary that that kind of support continue. And the Office of the Prosecutor has seized the opportunity that emerged in countries like Serbia and Bosnia to go beyond what was strictly in the mandate of the OTP and to actually contribute to capacity building efforts in those countries. One point that I think is perhaps among the most important to make is that local actors in the region, and again, these are the people who I think are the linchpin to magnifying the legacy of the ICTY, tell me every time I speak to them that their work is not over, and they want the international community to know their work isn't over, and that they need the international community more than ever. There's a perception that donor states who are absolutely critical to enabling those institutions to continue to thrive and grow and to face challenges have a sense of, done, we finished, we've given you enough time. There are a lot of other crises. And their answer is, we can do so much more, and we must do so much more, but we need the international community to help us. I want to turn to a final point, and Judge Ori has already busted us when we say final point, but really, this is at least a semi-final point. I want to turn to the question that also has been much discussed today, and rightly so, and that is the disappointing impact or failure of the ICTY to have an impact that many anticipated and hoped for in dispelling denial in the Western Balkans about wartime atrocities. So I want to make a couple of brief points about that. Of course, it's deeply disappointing that denialism is as high as it is and rising in recent years. What do I think the lessons of the ICTY for that experience is? One point I want to make is that based on the research I've done, the book that I've written about the ICTY's impact in Bosnia and Serbia, one of the pictures that emerged was that the ICTY's work did contribute to dispelling denial, both in Serbia and Bosnia, and I want to emphasize contribute to, in the early part of this century, so roughly until 2006 in both countries. And denialism has been on the rise, and very astonishingly so in Bosnia, but in both countries in recent years. And so point one is simply that the ICTY can make a contribution in this sphere. Second point is, but the degree to which it can do so turns profoundly on political conditions in the country. I think Lord Ashdown made that point very powerfully and repeatedly in this morning's session. And therefore, it's critically important. Obviously, not that the international community do all of the work of addressing local political conditions. Local actors have to do that and have to take the lead in that. But that we not lose sight of the desperate importance of remaining engaged. I think one of the stories, and I was happy to hear that Lord Ashdown confirmed this, one of the stories of Bosnia is that there was enormous progress in dealing with denial during the period of most robust international engagement in Bosnia. I don't think it's a coincidence that it was during the tenure of the two high representatives who were most robust in using, and had the permission of the Peace Implementation Council to use their most robust powers. It was during that period that we saw the most profound breakthroughs in addressing denial. So final point on that is simply that if we want to see the ICTY have the maximum contribution it can have in this sphere, we absolutely have to remain engaged. That's important for its own right, but it's also necessary to see the ICTY be able to make the contribution it can have. Final point I want to make, and this really is my final point, is that while the focus of this panel is the impact of the ICTY globally, and as my earlier remarks indicated, I think it's had a rather profound impact on norm diffusion. To me, its most important mandate has always been providing justice for victims, and that is part of its original mandate. I've done many, many interviews with lots of survivors in Bosnia. It's not surprising to anyone here that survivors have a rather lengthy list of criticisms of discrete aspects of the ICTY's record. There are many aspects of the record that they would have liked to see play out differently. Particularly in light of that, it has been remarkable to me that every time I ask a survivor at the end of an interview, which they've gone on at some length about their grievances, well, in light of everything you've just said, now that you know how this institution played out, do you think it was misguided to have created it? And then they get upset at me for asking the question and say, oh, no, 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 how could you even ask such a question? And some say that the ICTY was the best thing that's happened to Bosnia since 1991. And so to me, it's important to acknowledge that the ICTY gave something inestimably precious to survivors, and to keep sight of the fact that that was the most important mandate that they were tasked to provide. They were not tasked to dispel denial. They were tasked to provide justice, and they did something marvelously important. Thank you.
Thank you so much. There's many questions that I would like to ask, but I'm conscious of the time. And so I think we should just move straight to Prosecutor Serge Brammertz.
Thank you very much. Good afternoon, everyone. I'm very pleased to see some of our former colleagues and friends, and I'm very pleased to see colleagues from other tribunals. We have been asked to say a few words about what are the lessons learned of our tribunal for other accountability mechanisms or tribunals or courts. And I would like to just take 4 in the next 8 minutes. The first one, where I think what we have learned over the last 20 years at looking at the ICTY, but also other tribunals, is that, well, any tribunal or accountability mechanism is only as strong as its mandates permits. I mean, we have discussed today about the big successes. We have said many times, well, the tribunal or the ICTY had much more cases than other tribunals, more successes, no fugitives at large. Well, I think we had the strongest mandate coming from Security Council, obligation to cooperate, which I think was really fundamental. And if we look at everything which came afterwards, with a lot of progress in many areas, in terms of mandate, one cannot say that other other accountability mechanisms today have the same strength. We look at the most recent developments. If we look at the Syria mechanism, which we all know is very important, it's only the result of not agreeing in the Security Council on a referral or ad hoc tribunal. Well, it has a very limited mandate. If we look at the Iraq investigation team, which just has been put in place recently by the Security Council this time, well, the mandate is only to investigate crimes committed by ISIS and it's not a full situation. So we see that mandates are limited. If we look at the JIM, the Joint Investigation Mechanism on the Use of Chemical Weapons, well, the first mandate was just to determine if chemical weapons have been used, not to speak about accountability. The second mandate was to look into perhaps overall responsibilities. And once the JIM came up with results, well, we have seen a few weeks ago in the Security Council there was a veto and it was just cancelled. So my first conclusion is really an international organization which is looking for accountability is only as strong as its mandate is. And this is definitely the first lesson learned. The second one is that if we look at cooperation, if we look at cooperation from situation countries, you will only get the minimum cooperation necessary and never the maximum cooperation possible. We have seen it at the tribunal over many years. The first 10 years there were very little cooperation. And why was it more successful the last 10, 15 years? Well, because stick and carrot policy, conditionality policy by the US government in relation to the arrest of Milosevic, and later on in relation to Karadzic, Mladic, without the pressure from Brussels, nothing would have happened. And one of the lessons learned is here very, very clearly, is that international justice can only succeed if there is a political consensus. This political consensus, which was in existence 25 years ago, is not in existence anymore today. This is also a very sad reality, and I would be curious to know what the decision of the Security Council would be if the ICTY would have had to be set up today. So my point is that we had a political consensus. This political consensus is missing today. And we have seen that conditionality policy was very, very important over those many, many years. Third point, well, I think we have also learned that justice is best served if it is served closer to the communities affected. It was mentioned a number of times today that our judgments are very, very long. It's in a legal procedure which is not really understood in the region, which makes it very, very easy for many people in the region to distance themselves by saying, well, this justice coming from The Hague. It's difficult to understand. 1,000 pages for judgment is difficult to read. So I think that personally one of the lessons learned is very much that where possible, justice should be delivered closer to the affected communities, victims and perpetrators. That's why I'm personally quite a fan also of hybrid initiatives, always to look for the best possible way. If you can strengthen national jurisdiction that they really can work on complementarity and do it themselves, fine. If you have to give international experts, it's the second option. Third one is really to come up with a hybrid solution to have local ownership, making it more difficult for people to distance themselves, and international justice, of course, as ultima ratio if it is not possible to find a solution more locally. Fourth point is the integrated approach. It has already been mentioned a number of times. I think if there is one area where I think we have been relatively successful, is really in reducing the impunity cap in a very important way by having the ICTY really addressing the main responsible and having this very strong interaction with the region. As you all know, we started as a tribunal with primacy over the national jurisdictions. Over the first 10 years, there was very little cooperation, interaction with national prosecution offices. But what we have seen over the last 10 years was a very, very important impact. And the Security Council on this one was extremely helpful because by deciding about the completion strategy, by trying to put an end date, forced us de facto to intensify our cooperation with the region. And Sasha Kontic mentioned it this morning. We put a number of systems in place to have the judicial process working. Liaison prosecutors for the last 9 years. I think we are the only international initiative with Serbian, Croatian, and Bosnian prosecutor integrated in our offices. We have electronic access to our 9 million pages of database in The Hague. We have been very much involved in capacity building in the region, and we all know, and it was mentioned by a number of speakers today, it is only one chapter which is ending, but the fight for justice in the former Yugoslavia still must continue with a lot of international support needed. As you all know, in Bosnia alone, there are all more than 3,000 cases which are still ongoing. But I really think that by having this international approach combined with strengthening national authorities was very successful and really reducing very much the impunity gap, which also shows that we always say, or all the students learn justice delayed is justice denied. Well, at the international level, time is a very important factor, and what was impossible 20 years ago is very much possible today. So in this regard, I think this is one of the very important lessons learned. And perhaps, if you allow, you asked this question about the ICTY and the ICC. What are a little bit the lessons learned? What have we done well? What could we have done better? And I really think that if one would try to summarize it in one sentence, and of course it's a little bit exaggerated, one could argue that in the early days of the ICTY, probably indictments were much too large, and we tried to correct it later on by still trying to find a compromise between the magnitude of the crimes committed, but at the same time trying to keep a case which is manageable. For Karadzic and Mladic, when they were arrested, we reduced on a voluntary basis, more or less by 50%, the indictments. But I think that the ICC, with all respect, in the early days made the opposite mistake by trying to be much too small and too short in cases, putting much more responsibility on a very limited number of witnesses, which I think was perhaps correcting one mistake by committing another one. So probably the truth is somewhere in the middle. And the last word on the ICC, I mentioned it at other conferences before. Well, we are in this lucky situation that we have partners on the ground. So we have the completion strategy, we are closing the tribunal, we are transmitting the remaining cases, work files for the years to come to countries in the region. But this will be the big challenge for the ICC for many years to come, because sooner or later, you will need a completion strategy for each situation in which the ICC is working today. Because as long as a country is not getting better, as long as a country is not capable of addressing themselves atrocities, well, it will be difficult for the ICC to leave. I know that it's very difficult in a number of situations where there is no political support and where there is no real cooperation, but I think that everywhere where it is possible and where the ICC has a situation country, the international community should invest much more in building capacity in those countries to allow, at a certain moment in time, the ICC to withdraw and to concentrate on other situations in the world. Thank you very much.
I do want to move on, but can I ask you very quickly, do you see 11 bis as being playing a role as part of the ICTY completion strategy? And if the answer is yes, what effect, if any, does that lesson have on the role of positive complementarity and whether or not the organs of the court, the prosecution, even legal officers in chambers, a registry, whether or not they should give assistance to state parties to assist them actually conduct trials domestically?
You mean in the ICC context? Well, it has definitely been a very important part of our legacy to have first the legal basis to transfer 11 bis cases. I don't think that the ICC has similar provisions. And we also have today, I mean, it was not only the 11 bis cases, we also transferred more than 40 other cases. We call them category 2 cases, where we had case files which had not yet led to the finalizing of the indictment, but where we transmitted a very important investigative material. I think it was extremely important, and the legal basis was created to do so. We know that it's also difficult. But one of the big differences is really, that's why it's sometimes difficult to compare. We had to deal with one situation, if I may say. So as I said, we have 9 million pages of documents in relation to the former Yugoslavia. Last year alone, the liaison prosecutors from Serbia, Croatia, Bosnia have taken out of our databases more than 120,000 pages of documents to be used in national proceedings. We will definitely, within the MICT, for the next few years, transfer still dozens and dozens of cases to country in the former Yugoslavia. The ICC, the Office of the Prosecutor, working in so many different situations, has, of course, a much smaller amount of information available. So I think the opportunities to have this kind of cooperation will be smaller, but it still should be an opportunity to give more life to the complementarity in practice.
Judge Flug, over to you, please.
Yes, good afternoon. It's very problematic to be the penultimate speaker after a long, long day.
Almost last one, still one.
The penultimate.
Ah.
Yeah. The most important comes later, of course. But everything is already mentioned, not by me yet, and therefore I have to disappoint you. Some repetitions I can't avoid. My short presentation will be twofold, because I'm divided in a pessimistic person and a very optimistic person. I start as a pessimistic person. As Serge Brammertz just said, it was a very short period in time in the 90s where we had the feeling we will have a new world order after the Iron Curtain disappeared, and we had the feeling, oh, there is international cooperation. That was the background why the ICTY was founded. Now we are in it, and other institutions and courts and tribunals later as well, especially the ICC. Now we are again in a divided world, and I'm especially very disappointed that the horrible atrocities during the war in Syria didn't give reason enough for establishing a tribunal, an ad hoc tribunal about Syria. We could say the same about Yemen and Iraq and Central African Republic and Congo and other horrible wars. And especially disappointing is the position of the big powers in the Security Council. Those who are not members of the Rome Statute family, the ICC family, they are not giving the permission to investigate these crimes. And overall, my feeling is that the rule of law is under attack everywhere in the world. That means in Philippines, in Venezuela, in Turkey, but even in the European Union, if we think about the situation in Poland at the moment, this is really an attempt to abolish the rule of law and an independent judiciary. This is the background we have to face at the moment in the world. I could mention more. And I think especially disappointing is that the President of the United States has no respect for judges, for independent judges, and for the rule of law. The Security Council 93 had the expectation that the establishment of this tribunal would contribute to stop the atrocities, to put an end to the war, to establish peace, and to trigger reconciliation among the peoples in the former Yugoslavia. This was not achieved, especially not at that time. 93, the ICTY was founded. 95, Srebrenica took place. 99, the atrocities in Kosovo were committed. So the establishment of a court itself doesn't contribute to all that. The Security Council, of course, was aware of that, and we heard that earlier today already. The sole purpose, according to the Security Council resolution, the sole purpose of establishing the ICTY was to prosecute those who are most responsible for the atrocities committed. One comment I hear very often, but we have now the ICC. The ICC should have dealt with all, or should deal with all the situations and crimes, war crimes committed everywhere in the world in the future. That is a good idea, yes, but some of these situations would never be possible to be resolved by the ICC. 161 accused in the ICTY. How could ever the ICC, with the limited number of judges, the limited budget, be treated fairly and successfully as an ad hoc tribunal could have done? In the future, I think we need all these kinds. The ICC should be the most important institution, but we need ad hoc tribunals for other situations, like Syria and others. The situation in the former Yugoslavia is, many people referred to that already, very disappointing. The nationalism is increasing again, and therefore we have to call upon politicians, diplomats, scholars, teachers, churches and religious institutions, media, and the civil society, not only in the countries of the former Yugoslavia, but I would say worldwide, to contribute to establish peace, to reconcile, and to improve the relationship between the successor countries of the former Yugoslavia for a peaceful cooperation. Now I jump to the optimistic person. There is no way back to the time before the establishment of the ICTY. Impunity for those who were the most important commanders, military, police, and political leaders, this is no longer possible. And every commander of war crimes should be aware that one day he could be held responsible. As it was said just before, times are over that they will not, I'm very optimistic in that respect, will not return, that a dictator or a war criminal can spend with the money transferred from his own country to France, for instance, and spend the remainder of his life in a wonderful castle in France. This will not happen again. Of course, we have not a perfect system. Even domestic criminal system is never perfect. Not all criminals were caught and put on trial. This is, of course, never complete. But we have seen during the last 24, 25 years that it is possible to achieve something, and therefore I'm sure that it will continue. And we should see that we have now big libraries. Books and books and books were published. Carsten Stahn said, from the books into reality. To be honest, 25, 30, 40 years, books about international criminal law and criminal justice almost didn't exist. So that is an expansion with respect to scientific research, to publications, and even the scholarly field is now, has raised. Everywhere you find chairs of international criminal law, which in my country, in Germany, almost didn't exist 30 years ago. And we have a lot of well-trained, experienced experts who have served as interns, as staff members in all these institutions. I hope that they will fight for employment in institutions. It's very sad now at the end to say that at the end of the life of the ICTY, many of very well experienced staff members are now unemployed because the institutions are disappearing or shrinking, and only the wonderful ICC is almost left. So this is a very sad situation. But I would like to briefly refer to Stephen Hill, what he said about the impact of international criminal law on training of officers in NATO states. I can confirm that with respect to my own country, Germany. Young officers of the Bundeswehr, the German army, very often visited the ICTY, and I had discussions with them. They are aware nowadays that they have to abide by the law. The law, how to behave in war is very important. I don't think that this was a major topic in the 50s, in the 60s, and in the 70s. One, of course, I said I'm very disappointed about the denial of war crimes in the former Yugoslavia. It's not only denial, it's even worse. If I hear that there was a proposal to erect a monument for Ratko Mladic in Srebrenica, some days after the delivery of the judgment, this is frightening in a certain way, I must say. It will take generations to accept what was happening, and the ICTY judgments, I think, will give the basis, the establishment of facts for future generations to accept what was happening in that horrible time in the name of their people. One final remark. Once we had a visitors group from Serbia, young students from Serbia, and during the discussion I had with them, they asked me, what can we do? I was so happy to hear this question. My answer was, ask first your fathers, your uncles, your neighbors, what they have done in the name of your people, before you blame the other people, the other ethnic group. And that was a trigger of a wonderful discussion with this young student groups, and therefore we should trust the current young generation and the next generation. Thank you very much.
Thank you, Judge, for that very informative oversight. I'm not sure, objectively looking, if it's a very sad state of affairs that individuals, whether they're judges or lawyers, don't have jobs in international institutions. Because I think one of the issues is that these courts that are funded by the international community cannot become retirement plans for lawyers. And in fact, the argument must be that these lawyers, if they go back to their systems, they will spread the principles of international law that hopefully that they have benefited from when they've worked in these institutions. And this brings me back, I think, to an important point, which is if one is looking at legacy. In the early years of the ICTY, Patricia will bear witness, and others, I can speak for the OTP. The years I was there, right until the last year, there was no non-white senior staff, and all the senior staff came from developed countries. If one wishes to actually develop international law, even in the early stages, we should have regard, proper regard, not lip service, to both proper gender representation, senior positions and others, and also geographical representation, not just for the optics, but actually when these courts do close down or when people leave, it takes back certain knowledge to domestic systems. And the second observation I'll simply make is, I think everyone agrees that the ICC can't deal with 100+ cases in one situation. But the question is that necessary? In Nuremberg, of course, we know how many people were tried there. And the whole Special Court for Sierra Leone tried 10 accused in 10 years from trial to conclusion. So impact can be made by certain prosecutorial decisions that actually achieves justice and prevents, impunity. But I think that's a very useful oversight. President, can we pass the floor over to you?
Well, thank you very much, and good afternoon to everybody. Being a penultimate speaker was difficult. Being the ultimate speaker is even more difficult. Many of the things probably have been said. And actually, I've been adding some of the important points that were made by my co-panelists here, because I would like to also add some reflections on some of these points. But let me start by saying that I'm also extremely honored to be here on behalf of the ICC for this very important seminar on the occasion of the closing of the ICTY. I think, and probably this has been said all day long, it is absolutely obvious that the ICTY has really laid the foundations of modern international criminal justice. And it has had, of course, it's a huge precedent of the ICC, but it has really had a big impact on the provisions of the Rome Statute, and which was negotiated in parallel with the first years of the ICTY. Remember that the ICTY was created in '93, and in '94 negotiations of the ICC started and ended in '98. So while you were developing, the ICTY was developing jurisprudence, we were developing provisions of the Rome Statute. And some of the very important decisions of the ICTY are now reflected in the provisions of the Rome Statute. In some cases, you change the jurisprudence afterwards, but now we have them in our statute. So that's a problem. But thank you anyway. Also, but actually, after the setup of the court, you continue to develop jurisprudence that we continue to refer to in our cases. Even today, we were having deliberations on one case, and we were looking at the jurisprudence of the ICTY in the same point of law. So the Rome Statute is different. In some ways, it wanted to be different because also taking lessons of certain things that we wanted to change. But in many aspects, it's very much reflected of the ICTY. So there is no question that the ICTY will continue to live through the work of the ICC. And I'm sure that the jurisprudence will continue to influence also the other justice solutions at the national or international level. Now, at this time where the ICTY is closing and that the ICC is preparing to celebrate the 20th anniversary of the Rome Statute next year, I think it is a very good moment, and I thank you for the opportunity to come here to make some contributions, I hope so, to the reflections on what is the future of international criminal justice. And I thought that taking into account the work of the ICTY and also 15 years of operations at the ICC, maybe we could identify a few elements that, in my view, are crucial for the future of international criminal justice. And I have identified 4 points, like you, but you added a few afterwards, I think. I will stick to my 4 points. Well, first of all, the first feature for the future of international criminal justice is, I think we all agree that international criminal justice needs to be general. It really needs to be able to address all situations where crimes of this type occur in a non-discriminatory manner, in a non-selective way. I think this was indeed the rationale for creating the International Criminal Court as a permanent and a general court that would address situations of crimes all over the world and would not depend on the acceptance of a group of countries or a Security Council, for instance. So this rationale continues to be very valid today. But however, despite the fact that there is an international criminal court of a general and permanent character, we have to admit that international criminal justice continues to be extremely selective. It is addressing certain situations only, and we can see, and Syria has been mentioned here, and is of course a very obvious example of entire situations where horrendous crimes occur and that they are not being addressed, that they are left untouched. So I would very much agree with what has been said by Judge Miron in the sense that now there is a growing expectation for accountability. This is really well established in the international scene, and I think this is indeed one of the biggest achievements of the last 30 years, to accept that there must be accountability, to expect that there must be accountability. But this expectation is not realized yet. The International Criminal Court is general, but is not universal. It's not based on universal jurisdiction. It is based on the nexus of territoriality or active nationality, the nationality of the perpetrators. And the treaty has no universal participation yet. So it is for the court to be able to operate as a backup system to ensure accountability when everything else fails, we need first to become universal. And this is not yet there. We have 123 state parties. We need 70 more to be universal. So the campaign for universality is extremely important because we need to enhance the participation in the treaty if we want to have a general backup, last resort mechanism that can step in when other solutions are not available. So this is the first, I would say, feature for the future of international criminal justice in order to ensure that we can allow for a pattern of accountability. There has been some mention here about we see some impact when there is an investigation that is open and then the investigations, human rights have increased in certain countries. Well, this is great to know, but in order to have a deterrent effect, we really need to allow for a pattern of accountability to be established. So perpetrators know that certain sanctions will not be allowed and that certain crimes will not be allowed and there will be sanctions. Now, second feature, international criminal justice must adapt to contemporary forms of criminality. And I think it's very important to realize that the ICTY and the ICC, they come from a paradigm where we are thinking of perpetrators as dictators, and that was said here, political leaders, and of course, ensuring accountability for them is a huge achievement. But we also have to realize that now we are assisting new forms of criminality with a lot of non-state actors. And the example of ISIS that has been mentioned is extremely important. And actually, at the ICC already, all the convicted persons so far are non-state actors. And all ongoing trials, except for one, are leaders of militia groups, rebel groups, terrorist groups. So we need to understand this because this also brings a lot of practical, logistical problems, different types of investigations. Some of these groups also apply new forms of technology. So I think the future of international criminal justice is not just about dictators, human rights violators, but we also need to address this new phenomenon. And that is why also it's so important, and this has been also said, we need a holistic approach to justice, because here, more than ever, international criminal mechanisms will need to also be working as in complement or joint forces with national systems. When we see ISIS, where the membership is a multinational membership, individuals coming from different countries, it is obvious that international jurisdictions alone cannot address this. They will need to work together with national jurisdictions and other mechanisms. Now, the third feature. Yes. Do I have a few more minutes?
Yes, of
yeah,
course.
I only have 4 points. The third feature is that future international criminal justice must give a central role to victims. And I also very, very happy that Diane Orelliger here, she has mentioned the importance of the legacy of this tribunal is also how it has provided justice to victims. As you know, the Rome Statute system has some innovative elements in the sense that it not only is intended to provide justice to victims by way of sanctioning perpetrators, but also has a system of victims' participation and victims' reparations. This doesn't make the role of international criminal justice easier, and the ICC is still trying to cope with this new system, but we are gaining experience and we are getting better at it. We have so far 14,000 victims have participated in ICC proceedings, through legal counsel, of course. And we are getting better at providing them rights in the courtroom, but also we are getting better at reaching out to them, making sure that they understand what they are doing and facilitating their access to the system. I believe that these elements have been also taken up by other mechanisms that were created after the adoption of the Rome Statute. So it is consolidating as a trend, and I think it's an extremely important one, because, as I said, it doesn't make the role of international criminal justice or the proceedings easier, but it does maximize impact, and it does allow for getting closer to the affected communities, and I think, Serge, also you mentioned this as an important matter. And it also allows for the victims to really develop ownership for these proceedings. I think one of the problems of international criminal justice is that indeed we are conducting proceedings that are completely detached from affected communities, that are very far away. The court has tried to go to have some of the proceedings in situ, but it has not been possible yet. But in any way, the fact that they can participate and that they can come to the court and that they can understand our proceedings better, it does help to narrow the distance from The Hague to the affected places. And fourth and last point, and I see that this has been touched upon in terms of the procedure, I do believe that the future of international criminal justice is that it should be hybrid. As you know, the Rome Statute and the criminal system of the ICC, we did a huge effort, the drafter did a huge effort in trying to combine legal systems and traditions of the world, and basically civil law and common law. And we have indeed a hybrid system that is not always easy to understand, not always easy to apply. Different chambers have indeed sometimes given different responses to the same procedural problems. And someone asked about that. I do think that is a problem. I do think that we need to try to harmonize, and we do need to try to narrow the differences, and we have been doing this, or trying to do that to some extent. I think, indeed, this is a challenge, but I think we do need to strive for a more cohesive judicial culture. Even if I fully agree that that's extremely difficult to achieve in a multilateral, multicultural environment where you have judges from different backgrounds and different systems. But I think it is important and we need to try. But some weeks ago, we met some judges here. We met from different tribunals. We met in Paris to discuss and exchange views and reflections on lessons learned and difficulties that we were all encountering in our courtrooms. And one of the conclusions of this discussion, which was extremely interesting, was that there is no one legal system that is better per se to prosecute these type of crimes. That we really need to think hard and to try to take the best tools from each of these systems. We already have a system like that. It's very difficult to change or amend, but I think it is still the best solution is to try to combine. You cannot have a universal court that is identified with one system. We really need to combine and reflect them all as much as possible. And also, again, I think we need to look into ways of incorporating new technologies, new forms of evidence in order to accelerate our proceedings, because also the perpetrators are using different technologies. So I will finish my 4 points here. I will not add a 5th point, and I'm happy to engage with you. Thank you very much.
Thank you for that tour de force. Can I just ask, amongst the judges, if I can, why is it? Is it essential, do you think? Can we not escape the confines of the common law, civil law debate after 24 years of the ICTY, when there has been a development? And we have now not just a nascent body, but quite a mature body of procedural law that could be drawn upon. And sometimes one feels, and you may have been interested in your views, that it's we as lawyers don't let go to our parochial proclivities. But actually, if we just looked at the law and the procedure, there is now a sui generis body of procedural law, and we don't need to keep reinventing the wheel or have these parochial debates about which is a better system, because of course both systems fit their own confines very well. Can we not escape that constant monotonous debate?
No. I wish we could, but it's very difficult. Indeed, there is a law. Actually, the ICC, which is also different from the ICTY in this respect, that it needs to apply entirely state-made law. You know, in the case of the ICC, the drafters, state representatives, not only drafted the rule, the Rome Statute, but also the rules of procedure and evidence of the court. And if we want to amend some of these rules, we can propose amendments, which is already extremely complicated at the court, but these amendments need to be adopted by states. Now, that is not the major problem, and actually our system is quite detailed, so it should be easier, as you say, to simply say to all these judges and all these prosecutors and legal officers that come from different systems, to simply say, forget your system, apply this law. Well, in practice, it never works that way. The law, even if it is detailed, always gives a margin to appreciation and interpretation, and each socialized lawyer of this world will tend to interpret the provisions as it has been interpreted in their own system for the last 20 or 30 years. So they come with this background, and they tend to try to interpret things in the way they see them at home. That's why I think these international institutions do need to make a proactive effort to integrate new judges. At the ICC, on top of that, every 3 years we have 6 new judges that replace 6 judges. So by the time you manage to create some kind of a cohesive or more cohesive culture, you have these new people coming, which is great because it comes with new ideas, fresh ideas, but you need to integrate them and you need to make a proactive effort to create a more cohesive judicial culture. But the law in itself doesn't do it in practice. Thank you.
Thank you so much. Could I just ask, because we started late, can I ask Mirella and Carsten, how much longer do we have? I note the time, but we started late. Do we have time for some questions? Okay, so perhaps we'll forgo the second round and open it up to questions to the panel.
Former Soviet Union, one of the most repressive regime in the history of mankind, invaded Afghanistan, committed war crimes. And my question is, if ICC, the prosecution department of the ICC, ever considered to compile a file of those responsible for the invasion and the war crimes, including Mr. Putin, because he too was one of the policymakers and in the implementation department of the then regime. Thank you very much.
Thank you very much. My name is Mustafa Nada. I'm with the Embassy of Egypt. So thank you very much for the elaborate presentation. My question is, it's actually a comment first. I think it's quite unfair to compare the ICC to the ICTY, because in the case of the ICTY, we've seen the political will of the international community present. You can recall, for example, UN Security Council Resolution 1207, which was quite supportive of the cooperation between the court and the different states. So my question is that, looking at the narrative of the ICC, especially the statements of the prosecutor before the Security Council, nobody can deny that there is an alarming level of frustration with the Security Council. So my question to you is that, what is the way forward to deal with this impasse? Thank you very much.
Thank you. So this is not a day when we're going to hear about structural problems with international criminal justice, how they address mass atrocities. So I just want to focus on one point, which is a legacy from the ICTY, is the selection and training of judges, which I think it's either a good or bad setting to do this, because there are a lot of judges present. But one thing we see from the ICTY to other international tribunals, including the ICC, is that the selection of judges and the election of judges is a highly diplomatic process. And to be honest, even though there have been, and even in this room, highly qualified, very competent judges, there have also been judges who have had no background in criminal procedure, who've never conducted a criminal trial, who have no knowledge in international criminal law, and who ended up in the highest institutions of international justice. And it was the case at the ICTY, and it's also the case at the ICC. So I was wondering if the panelists, but also the judges on the panel, with honesty will address this issue and wonder, for example, if the ASP should not be in charge of selecting judges, and there should be a different process of selecting judges, like defense lawyers who have 20 years of experience in criminal procedures, like prosecutors. Why not apply the same standards to the other actor and the main actor of international criminal justice, which are judges? Thank you.
Thank you. Then the last question, and then it'll go to the panel. Thank you.
Good evening to all the panelists. So my name is Sharon. I'm a journalist, international journalist. My question is a general question, and then this is for all the panelists right now. In your own point of view, how has the identity of ICTY changes over the past 24 years in your own perspective? And another question, is what are the remaining priorities of ICTY?
Could you repeat the second question? Sorry, just the end of the second question.
The remaining priorities of ICTY now.
The remaining priorities of the ICTY. Okay, thank you. So I'll leave it to the panel to answer which of those 5 questions. Well, I'll leave it to the panel. Do you want to take any of the questions?
Yes, the last one I would like to answer. I'm retired now. By the end of November, all trials are closed. The tribunal is closed. There's only one judge left, it's the president, to clean the office. That's all. So, no, sorry, I can't answer differently. The other question about selection of judges, you should not put this question to judges. We were candidates and we were elected or appointed. The procedure is a political procedure. It's very diplomatic, it's political, that's true. And there is maybe a problem with respect to quality. That may be right. I always said it's always an asset for a judge to have seen a courtroom from inside before in his career. So it helps to understand what is happening in the tribunal. Although I must say, this is not so important for the appeals chamber, it's more important for the trial chamber to conduct a lengthy trial. But yes, look into the statute of the ICTY. It was your question. There's even not mentioning of the necessity that the candidate must have studied the law. It's not there. So ask the Security Council why they have set up this statute in that way. We, the judges, can't answer that. And I was a judge before, despite other positions I was holding.
So hoping that I understood your question. Oh, I'm sorry. Did I misunderstand? Okay. So I'm not sure I understood it, but let me say this about how the ICTY has changed over time. I would say it's a slightly different point, but related, that the way we assess the ICTY, we, the international community, has changed over time. To say the obvious, it was early on natural to judge the ICTY by the simple question whether it could function at all. And so a lot of the early assessments of it were all about whether it could even conduct trials, whether it could even get defendants. And it's easy now to sort of underappreciate how important that was, but it's astonishing that they were able to get some fugitives like Ratko Mladic, who were extraordinarily elusive for a really long time. After that benchmark was sort of not fully satisfied, but on its way to being satisfied, we assessed it, we, the international community broadly, by its jurisprudence, which has been transformative and has found its way into domestic case law, and its impact on global courts generally, so the institutional impact. I think it took a long time for people to start assessing the ICTY by its impact on local judiciaries and local communities, and I think it's been just tremendously important that our focus has shifted in the past decade so that we assess it today as much by its impact and its partnership with local communities as by its impact externally on the international community broadly.
Thank you. I know President Miron and President Silvia Fernandez de Comendi have to want to answer questions. I'll also ask Judge Miron and Judge Silvia if you could also give your concluding remarks of this panel. So answer the questions, but feel free to also any concluding observations that will close this final legacy event. Thank you.
I don't think I would dare give concluding observations on this colloquium, but I would like to make a comment or two, starting with the point, a very interesting point made by Professor Jacobs. Now, all elections, special elections by a group like the Assembly of State Parties, are by their very nature political. And Judge Fliege made it very, very clear, the role of politics in elections. But I think that the criticism for those cases in which perhaps not the very most talented people and qualified people were elected as judges should not be directed really to the Assembly of State Parties. It should be directed at the governments that choose to nominate those people. And there must be a very strong sense of responsibility. A state should not nominate somebody because he's a cousin or a friend of the prime minister or foreign minister, but because the person is qualified. And as long as we don't have that, we should not expect any panaceas from changes in bodies such as assemblies of state parties. The second general point which I would like to make pertains to the quest for harmony of international criminal law and especially international procedural law. It is a point which my friend Sylvia mentioned and explained extremely well. I think that more perhaps could be done. I would very much like eventually to see more alignment between jurisprudence of other courts and the ICC. There are 2 points in this respect that I would like to make. First, regarding the rules of procedure. We learned in the tribunals that giving this quasi-legislative power to judges to write their own rules of procedure has great advantages. It is faster, but even more so, judges are more qualified than anybody else to draw conclusions from the needs arising in management of the courtroom. They can translate those rules to rules of procedure. I realize that we perhaps did not always make the best of the possibilities that the mandate gives us. But nevertheless, I think that the system, in terms of the multiple revision of our rules of procedure, worked. I remember when I was still a professor of international law, I used to criticize the frequency of changes in our rules of procedure, making comparison between those changes and changes of constitution in some countries that I will not mention. But I think that basically the system works in that respect. The second point pertains to substantive law. Judge Pokar spoke today of the importance of international customary law in the jurisprudence of the ICTY, perhaps a little bit less, but nonetheless, in the jurisprudence of the ICTR, and potentially in the jurisprudence of the ICC. And he made the point that the statute of the ICC, detailed as it may be, leaves still some gaps for international customary law to fill in the future. Article 21, I believe, of the statute of the ICC leaves certain possibilities to be filled by customary law, but even more so, we must remember that with regard to states which have not adhered to the statute of Rome, and who may choose, in case of certain conflicts, to accept the jurisdiction of the ICC, the principle of notice in advance to people who commit or might think of committing crimes, which is part of course, the principle of legality, would compel the ICC to resort to customary law. Because while we may satisfy the notion or the requirement of notice, by telling people, well, you have the statute of the ICC, you can read it and know in advance what you may and what you may not do with regard to states which have accepted the statute for purposes of a particular conflict after the conflict has started, and presumably, or potentially after crimes have been committed, you can only go to customer law in order to satisfy the principle of legality. And therefore, at least through the principle, through customer law, we can see a greater rapprochement or harmony in the future between the tribunals and the ICC.
Thank you so much. And the last word, over to you.
Thank you very much. Can I add one thing on before giving some concluding remarks on this issue of election of judges, because it is one of my favorite subjects as well, and I think it's crucial. It is crucial, absolutely. Yes, it is a political process. The candidates are nominated by states, are elected by states, and yes, they do like cousins and other relatives. But I would say that, first of all, it's not so easy to say who is a good judge for this type of courts. Yes, having been in a courtroom helps. Yes, having studied law also helps. But we also we need to understand that we are dealing with extremely complex crimes that also require a huge amount of common sense. That is also great. But commitment, hard work, and also a collegial attitude, because it's very difficult to create a cohesive judicial culture if you are working with individuals that do not have this collegial team instinct that allows them to work together with others. Because I really believe that the type of crimes, the type of problems we have to deal with is really far beyond what one person individually can deal with. I think you really need to be able to consult with others, to do a collegial work in order to find the best responses. In the ICC, we don't escape from these political nominations and political process, but there are some efforts to make the system more transparent, to make the system less political, and we have this advisory committee on nominations that, of course, is not perfect, but it's a very good first step, and I really support very much their efforts to try to interview the candidates and make recommendations. And also you have civil society organizing debates in order to expose the candidates to the world. So there are efforts to make it less political. Of course, even these efforts, is very difficult to assess certain qualities that I have mentioned that sometimes are not apparent in a CV, but still, I think they're very, very good efforts that we need to support. Now, if I may, concluding, and actually also hoping to address somehow some of the questions that were made about the political support that the ICC gets, for instance, compared to the political support that the ICTY received. But also, I think Serge Bramers also said, well, would the international community create the ICTY today, for instance, if they had to? And the same question was being asked in New York in the Assembly of State Parties last week. Would the International Criminal Court would be created today if we had to start all over again? I think we all understand that we are living in a far less benign world probably than the 90s, where idealism was at its peak, where, as Judge Fluger said, everybody thought that we were creating a new world order. And these tribunals were created then. So whether they would be created today, I don't know. But what we do know is that we have a huge advantage. Maybe the world is less, is more difficult today, I don't know. But we have the huge advantage that these tribunals were created. And they have worked for almost 3 decades. And nothing can erase that, because this expectation for accountability has grown, has solidified, and is there. So it may be that we go now into a little bit of a more of a low period where things may not be so easy as we would like to, that we might be frustrated by lack of cooperation in certain instances. But I think this expectation for accountability is very strong, and it will not be easy to erase it or change it. So we should not take justice for granted, but I do believe that it has matured and is strong enough to survive difficult times. Thank you.
And I think that's the perfect note upon which to end the panel discussion. Thank you to each of the panelists for your excellent contributions. Thank you.
Ladies and gentlemen, thank you very much. I would like to emphasize that today we've had 27 speakers, 4 panels, and within 10 hours, and that seems to be a part of the legacy on its own by the ICTY. We would like to invite you to now celebrate with us downstairs at the reception. I would like to thank all the speakers, and each one was a very unique and special contribution by itself. And thank you to the audience, and of course to the colleagues at the ICTY who have supported this event. Thank you.